United States versus Yunis. The facts of the case are as follows. Yunis and several accomplices hijacked a Jordanian airliner while it was on the ground in Beirut. The plane flew to several locations around the Mediterranean Sea and eventually flew back to Beirut, where the hijackers blew up the plane and then escaped into the hills. The only connection between the whole event and the United States was that several Americans were on board the whole time. Yunis was indicted for violating the Hostage-Taking Act. He was apprehended and later indicted under the Destruction of Aircraft Act. He moved to dismiss on grounds of jurisdiction. Yunis argued that the government could not prosecute him for a hijacking that he perpetrated when its only connection to the United States was that several Americans were on board the plane. The issue in this case is that may the federal government prosecute an airline hijacker even if the hijacking's only connection with the United States was the presence of several Americans on board the plane? The court ruled as follows. Yes, the federal government may prosecute an airline hijacker even if the hijacking's only connection with the United States was the presence of Americans on board the plane. There must be jurisdiction under both international and domestic law in order for jurisdiction to exist in the situation of this case. International law relates to the power of Congress to have extraterritorial application of its law. Domestic law relates to its intent to do so. International law recognizes several bases for a nation to give extraterritorial application to its laws. One is the universal principle. Some acts are considered to be so heinous and contrary to civilization that any court may assert jurisdiction. The acts that follow within this category are mainly defined by international convention. The universal principle applies because numerous conventions condemn hijacking and hostage-taking. The passive personal principle is also relevant, which also apply to offenses against a nation's citizens abroad. The United States has been slow to recognize this principle, but it's now generally agreed upon. International law having been disposed of on this issue, domestic law must now be discussed. The hostage-taking law at subsection B1A clearly includes an offender that has seized or detained a U.S. citizen. The language could not be plainer. With regard to the Destruction of Aircraft Act and Federal Aviation Act, the law was intended to apply only when the aircraft in question either began or ended its flight in the United States. Since the flight in question did not do this, the act does not apply